Day 2 of the Asia ADR Week 2023 began with a session entitled Advancing Towards Zero Dispute, the Role of the AIAC SFCs in Spearheading Dispute Prevention. This session delved into avoidance-aligned clauses, international standards for specific projects, and innovative mechanisms to prevent disputes. Ms. Tan Swee skillfully moderated this session, while speakers Mr. Nicholas, Mr. Darshendev Singh, and IR Kok Keng provided profound insights into the construction sector's path to a dispute-free future.
A very good morning and a warm welcome to the Asian International Arbitration Center. It's a pleasure to meet you all again. Thank you for coming physically. I understand last night was a very long night. We thank you all for making the trek in today physically. We'd also like to thank all those tuning in virtually, at the moment numbering just over 60. We're here to kickstart the second day of our Asia ADR Week 2023. Our first session today is entitled Advancing Towards Zero Dispute, the Role of AIAC SFCs in Spearheading Dispute Prevention. Without further ado, I'd like to call upon our moderator, Ms. Tan Swee, on stage to kickstart the session. Thank you.
Morning, everybody. Actually, absolutely amazed to see all of you here after last night. I gather it was a pretty good evening, and we hope that we'll keep you awake this morning. So my name is Swee. I am an arbitrator, and I'm with 39 Essex Chambers, and my office is right downstairs, actually. I'm going to be joined today, I'm going to be flanked by a couple of young men. And the first one I'll call on stage is Darshendev. Darshendev is a partner at Lee Hishamuddin, and he deals with, surprise, surprise, construction engineering. The next person I'd like to call on stage is engineer Kok Keng. Is his, with his IR in front of him, anyway, is an engineer, but he's really more into the claims side of things. And then we have Nicholas Gould, who's joining us virtually from Singapore. Nicholas, are you there? Hello, Nicholas. You're muted, I think.
How's that? Can you hear me now?
A lot better.
Brilliant. Thank you very much. Nice to be with you.
So although we don't have so many people here, I understand that we've got over 60 people who are lounging around in their pajamas and watching this virtually. So we'll kickstart this. And to say that we are going to be dealing today with the AIAC SFC. Now, it's very difficult to say that after a heavy night out. And SFC just means standard form of contracts. So this is something that has been in the making for quite some time. And I think AIAC as an arbitral institution is a very unusual arbitral institution to venture into standard forms of contract, normally left to institutions like the engineers, for example. So to kickstart this, let me ask you this first question. Who has seen this? Oh my goodness, not a single person. Oh dear, 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 dear. So, second question, have you heard of it? No. No, Ezra, you don't count because you're with the AIAC. And the third question is that, have you heard of anybody who's heard of it? Oh, obviously not. Darshendev, you've got a hell of a session in front of you. I'll tell you what, the idea of this session is that we'll discuss why you may wish that you've heard of it, why you may wish that you've got a copy in your hands, and why you may wish that your project was actually being run on the SFCs. So, we've got a few slides here. Help. Help? Help? Do we have slides? Okay, that's Darshendev. And Darshendev doesn't really have slides, so this is just a holding point for him. Darshendev's going to tell us a little bit about the SFC, and then we'll take it from there by way of a discussion. We don't want to bore you, we want to engage you. Okay, so over to you, Darshendev.
Thank you very much, Swee. Very good morning to all. I just thought perhaps instead of having the conventional style of having a slide, it might as well that you hear me speak. Perhaps you would appreciate me better. Very good morning once again. The purpose of my talk essentially is to basically deal with the AIAC SFC. What it simply means is AIAC standard form of contract. As you may or may not know, there are 5 types of contracts that have been come out by AIAC. First is the building contract. Second is the building contract for subcontractors. And then you've got the minor works. Then you've got design and build for main contractor and design and build for subcontractor. For purposes of today's discussion, I'm going to focus on the building contract for the main contractor. The topic, as it says, is working towards zero dispute. Well, I'm not sure whether in construction industry, having done this for many years, whether you could actually achieve zero dispute. But certainly what I intend to do today is to highlight certain provisions in the SFC which may lead towards minimizing the disputes. And these are the features of the SFC. Since it's the AIAC SFC, I've also taken the trouble to basically frame my topic based on an acronym, which is AIAC SFC. The whole purpose is by the end of my presentation this morning, if you ever think of minimizing dispute, you will think of AIAC SFC. So let's kick off with that.
You got 10 minutes, okay?
Okay, sorry. So let's kick off with that. So A, I would say, is administrator. What it means by administrator is that in the SFC, there is a position for a contract administrator. Typically, in construction contracts, the administrator is either the architect or the SO. But in this SFC, it allows a party the choice to pick the contract administrator. So the contractor has a say in it. Only if when agreement cannot be reached, that's when the architect will step in. The other thing about the contract administrator is particularly when it comes to giving of instructions. As we know in construction industry, there may be disputes as to whether an instruction was given, and there many a times instructions are given verbally. So in the SFC, the provision is that if there's an instructions given, and if a contractor writes back to the CA and says, look, this is the instruction, the CA has an obligation to revert within 5 days to object that that wasn't the instruction given. Otherwise, it will be deemed that the instruction has been given. Similarly, when an instruction is given by the CA, and if you think that the instruction is not in accordance with the contract, you can, within 3 days, write into the CA to ask him or her to provide reasons, including the relevant provisions in the contract of which your instruction was based on. There are also instances where the architect or the CA perhaps is based in a state which is quite far apart from where the project is, and he leaves it to its resident architect or even the site staff to deal with the day-to-day instruction. In that situation, the contract states that where site staff gives you an instruction, the CA has an obligation within 3 days to confirm that instruction for it to be valid. So that's essentially as far as the administrator is concerned. The next alphabet is I, which is inspection. So what SFC allows is that post-termination, within 14 days, the CA must write into the contractor to have a joint valuation of the works that have been carried out and the materials that have been delivered to the site. And whether or not the contractor participates, a decision would have to be made within 28 days. So this promotes minimizing dispute, because at the end of the day, when you go to arbitration, there will be, instead of disputing on the value of the work done or material delivered on site, the parties would have at that material time sat down and come to a joint inspection, and they would presumably be expected to sign off the joint inspection seal. The third alphabet is A, which is acceptance. And acceptance here is, and I find this quite interesting because many a times you realize that a work have achieved practical completion, or the defects in the works have already been completed, but the administrator refuses to issue a CPC or refuses to issue a CMGD. How do you then deal with it? Many a times you have to rely on case laws to support your position that irrespective of whether a CPC was not issued, the work have achieved practical completion. So what have been included in this SFC is a provision that in the event that the contractor writes in for an application and within 14 days the application is not rejected, CPC or CMGD will be deemed issued. Or even if it's rejected, as long as you can prove that the works in actual fact have achieved practical completion, or it has achieved a state where a CMGD ought to be issued, it is deemed that the CPC and CMGD has been issued. So that I found it to be quite interesting. The fourth point is C, which is changes. Changes are essentially variation. As far as variation is concerned, it has a timeline within which you must evaluate the variation. Many a times in construction contract, you realize where a variation claim is submitted, works has to be carried out, but the administrator either intentionally or unintentionally chooses not to evaluate the variation till the end of the project. Whereas in this instance now, you've got a timeline within which you must evaluate the variation. The fifth letter is S, which is substantiation. This is also interesting because, as you know, in many construction contracts, we are required to submit progress reports on a monthly basis, on an interval basis. But I hardly find many contracts where it actually stipulates in detail what needs to be in a progress report. In this SFC, it actually lays out that unless otherwise instructed by the CA, it has a fairly long list, and I think it's a fairly detailed list. I won't go through the list now. You can read it for yourself. But it's a fairly detailed list in terms of what are the what needs to be included in the progress report, including, I think, status of application, what's your current progress, etc. So that is as far as S is concerned. The next alphabet is F, which I would say is fees. And this is particularly when it comes to dealing with nominated subcontractors and nominated suppliers. As many of you may know, one of the problems in construction industry is that when the employer pays money to the contractor, contractors sometimes do not pass through that cash to the subcontractors or the suppliers. So while contractors are getting paid, the persons who are actually doing the job on site, when it involves, they are not doing the job because they said, I'm not being paid. So how do you overcome this? Traditionally, if there is a, which I think, for example, in PAM, standard form of contract, the architect standard form of contract, what it says is that the employer or the architect could actually write into the contractor to provide reasons as to why shouldn't I pay directly. And if the contractor provides a reason for withholding, you cannot then proceed to make direct payment. When I read the contract, it seems that contracts like PAM, the administrator doesn't have a choice to make a view as to whether or not I agree with the position taken by the contractor. Many a times contractor can deliberately, without any justifiable basis, just impose certain deduction just to block the cash flow from going to the nominated subcontractor. Whereas in this SFC, the provision states something to the effect that I, as the contract administrator, can assess for myself whether is the reason given reasonable or justifiable. Even if the contractor says, I'm deducting this, please do not pay. If I find that reason to be unreasonable and unjustifiable, that allows me to bypass and pay directly to the nominated subcontractor and the nominated supplier. So this I find this to be quite interesting. And there's also a provision for final payment. What this simply means is that at the end of the contract, where the contractor is not due for its final payment yet, but the nominated subcontractor has finished his job, it gives a mechanism for the contract administrator to release payment directly to the NSCs and deduct that by reducing the retention sum that is being held by the employer against the contractor. The final alphabet will be C, which I've termed it as compensation. This is particularly when it deals with delay damages or LAD. As you know, in many contracts, construction contracts, there could be sectional handovers, sectional completion of works. But you rarely find where sectional works are handed over, the LAD rates are reduced, or even the retention sums are reduced. So the SFC allows that where there is a partial handover, that allows a mechanism for there to be a reduction of LAD, issuance of CMGD, DLP will start, CMGD will be deemed to be issued in respect of those relevant parts which have been handed over to the employer. And there's also provisions in the SFC which allows for, which basically is in line with the provisions on basically to make it a bit more difficult for the contractor to challenge the imposition of LAD on the basis of it being imposed unreasonably, etc., in line with the reason authorities. So in a nutshell, that's where I think are the key points in the SFC which allows, or which I would say promotes towards minimizing dispute. Of course, not to forget, the SFC is the very first standard form contract which is in line with SIPA, or the Construction Industry Payment Adjudication Act. It has provisions dealing with SIPA, particularly in terms of your extension of time and loss and expense, as well as provisions dealing with when direct payments are made to the employer. So to summarize, A, administration, I, inspection, A is acceptance, C is changes, S is substantiation, F is fees, and C is compensation. So where I said earlier, if you think of minimizing your dispute, think of AIAC SFC. Thank you.
Thanks very much, Darshendev. That was quite the canter through the AIAC SFC. Could we get Nicholas back on the screen, please? So what we wanted to do was just engage with you, engage with the speakers about a little bit of a discussion with regards to the AIAC standard form. Now, I know that what Darshendev has just cantered through is quite a lot to take in, but you can always contact him at Lee Hishamuddin and get more of his notes from him. So I'm just going to kick off the discussion before I open it to the rest of you. Darshendev, aren't these just normal construction clauses? Our topic is about moving towards zero disputes. How do these clauses that you took us through work towards zero disputes?
Thanks for the question, Swee. I think as I was delivering my talk earlier, I've in a way hinted a few clauses. Well, as I see it, it may appear at first glance to be a normal clauses, but if you read in further in terms of the wordings that have been used, I don't think many of them are in the usual standard forms of contract. Like for example, even taking the administration point of view, how many contracts allows the contractor to have a say on who is the contract administrator? I mean, we've been in the construction industry. We know most of the time the contract administrator is someone who is employed by the employer. He earns a fees from the employer, although he is supposed to be independent, which I'm sure in most cases they are. But where do you draw the line? So this is the first time I'm seeing where the contractor has a say in it. Whether practically it's going to work, it's yet to be seen. But I guess if both parties have that common objective of upholding what was intended to be achieved by this provision, I don't see why it wouldn't be achieved. So yes, so that's one of the examples.
Well, I actually do think that this is actually progression, because many of you were too young to remember this, but way back in the late 90s, I spent many a day helping to draft the CIDB, the Construction Industry Development Board Standard Form of 2000. And we had a lot of these kind of provisions, But at that point in time, it was completely rejected by the industry as being too contractor-friendly, on the basis that contractors should have no say in anything. But if you look at what has happened in the last 23 years, culminating, I think, in this, as well as the FIDIC and all the other forms, including the PAM form here, contractors are starting to have a little bit more of a say. Nicholas, anything to add that we can talk about?
Yeah, I think the helpful and interesting thing about the way that some of these clauses have been drafted is that it helps people that get involved in the contract to think a bit about what they're doing. And of course, it comes down to people, doesn't it, still? People create disputes or end up in the middle of disputes. But if they look at the clauses in the contract and if they approach them proactively and try to cooperate, then that goes a long way towards dispute avoidance. So, I think it's always good to slowly move on with standard form contracts as part of that educational process of helping people in the industry think a bit more about what they should be doing. So from that perspective, I think it's certainly very helpful. And you said that surely these terms are very similar to other contracts, and I suppose some are, but you also said that they're developmental and they're moving on, and I think that's the important point here.
Okay, anything? Later? All right. So, ladies and gentlemen on the floor, trying to wake you up a little bit. Is there anything that you'd like to bring up for discussion? Because I think that if most of you have not even heard of this contract and you let alone use it, I mean, this is the time to try and find out how it can help you. Anybody? David, could you take the microphone, please, David? Introduce yourself, who you are, where you are from, company, all that kind of thing, shoe size.
Oh, does that work? Oh,
Yes.
Excellent. David Gibson, I'm CEO of the DGA group, visiting Singapore and Malaysia for a couple of weeks. This new form of contract, I just wonder if there's any consideration for early warnings, which have been introduced in other forms of contract in the last couple of years, because I found that very helpful to the parties to flag issues early and to collaborate to try and obviously manage those risks as they emerge. Thank you.
Thanks, David. Darshendev?
Yes, I think there are provisions. I think Ang, you were mentioning about the early warnings earlier, right? Maybe you want to deal with that?
Sort of.
Yeah. Perhaps I think Ang could address that.
Maybe just to add to Darshendev is there is a revised CIDV contract being carried out currently. I was invited for the simulation event. For that, I think they have incorporated the early warning system as per the NEC contract. But I think that will be another forum. Okay, but later on I will just show how actually we have been implementing early warning system in our site management. But that will be for later. I don't want to spoil it for everyone. Thank you.
So I think that to answer your question directly, David, that in the AIAC form, there isn't a specific NEC style early warning system. But as Ang has mentioned, the CIDB new form of 2023 is going to be officially launched shortly. And they do actually incorporate the early warning register as well as a compensation event borrowed from NEC 4. So I think that definitely this is some room that the AIAC can move towards. Nicholas, anything to add about that?
No, only other than that I do think that early warnings are helpful and have become quite a useful mechanism, particularly when you use them with risk registers, because it allows people to think about problems that they're perceiving are coming up in the future, rather than just arriving at them when they're happening, and that, of course, creates a more difficult situation. But again, it comes back to people thinking forward and wanting to use those mechanisms and making the most of them.
Yeah, and this is something that leads into a question that I have as well. When you talk about dispute resolution, and really this is something that I'll open to everybody. When you talk about dispute resolution, for most people, they go to the back of the contract, look at the very last clause, and look at the dispute resolution clause. Nobody seems to think about the rest of the clauses. And I'd like to invite comment as to whether dispute resolution ought to be looked at from the other clauses, not just your last clause. Darshendev?
Yes, thank you, Swee. I think many a times I've been involved in some of the contract drafting. Many a time parties focus on the commercial terms, and the last thing they look at is the dispute resolution clause. And I've seen cases where the dispute resolution clause are not well thought through, and it's just copy pasted into the contract based on some other standard model clauses. And when the dispute actually arises, you tend to realize that having 3 arbitrators with the arbitration seated, say in London or Paris, when the dispute is such a small sum, was something that shouldn't have been done by the parties. So on that note, I do agree that dispute resolution is not so much focused on the dispute resolution clause, which is equally important as well, but it also is to be embedded into the other terms of the contract, which is what SFC is hoping to do. Because when you have when you minimize the dispute from the start, when it goes to the dispute resolution process, you have to deal with either less issues or less complex issues.
Anything to add, Nicholas?
Not
really.
Well, I was going to say, without focusing on any particular terms, one thing that should be happening if the parties get into difficulty is looking at the contract to see who might have those risks or to determine what they should have done, and kind of bargaining over what the liabilities and positions are. And that isn't always done, is it? Sometimes people adopt positions that may or may not be wrong at all. They never really look properly in the contract. And it's when you get to the arbitration later on, you find out that there wasn't a claim or there was a claim. So I think, it's quite important not to look just at the dispute resolution clause, but also the rest of the terms. And people don't do that, do they? They sometimes leave the contract in the drawer. You do this a lot in construction. Put the contract away, just build it. That's all that matters. But when you get into difficulties, it's important to look at the risk allocation rather than just hold your position to the end of the project and then hand it over to the lawyers and the experts at the end and let the arbitration run. Because one, I suppose, comforting aspect of that is you'll be on another project years down the line somewhere else, and you can blame it on the arbitrators getting it wrong rather than you adopting a position because you didn't look in the contract. So there's a lot to be said for opening up and having a proper look.
Right. So basically, get really involved right from the beginning. Now, in this room, we've got a lot of construction lawyers, we've got claims people, we've got administrators. So any views that one can offer or want to offer? No? Okay. If that's the case, then perhaps I can move on to another question. And I'm going to hit on Darshendev again. You talked about the standard form of contract being SEPA compliant. 2 things come out of that. Firstly, how is it SEPA compliant? And secondly, how does that help to avoid disputes? This is a very Malaysian context because SEPA being the statutory adjudication for the construction industry here is pretty much the name of the game ever since it came into being.
Thank you, Swee. And I think to add to that, you're right. Many years ago, before SEPA came on board, there were complaints that employers were imposing LADs to try to block payment. So the word on the ground was, if you don't do as what I tell you to do, I'm going to LAD you. But now it has turned. Since SEPA come on board, the contractors are telling the employer, if you don't pay me, I'm going to SEPA you instead.
It's now a verb.
So against that context, let me give a bit of background. There are two provisions in SEPA which is very useful to a winning contractor. One is in Section 29 SEPA, which allows the contractor to suspend works in the event that the adjudication decision amount is not paid. And once you suspend works, you are, as a matter of statutory right, as enshrined in SEPA, entitled to not only extension of time, but also to loss and expense for the period for which the works were suspended or the progress were reduced until the payment is eventually made. Now, what SFC allows for is it includes provisions to that effect that supports Section 29 of SEPA. But one may ask, if I've got an adjudication decision and at the same time I'm entitled to extension of time and loss and expense, what happens down the road, a couple of months or even a year down the road, depending on the matter, goes up to the High Court, Court of Appeal and Federal Court, eventually the decision gets set aside. Do I then reverse the extension of time? Do I then reverse the loss and expense? It's unclear in SEPA. But SFC includes provisions to that effect, that in the event that it is eventually set aside, the position reversed. So that is as far as Section 29 of SEPA is concerned. There's another provision under SEPA which is Section 30. Section 30 allows the winning contractor or the winning claimant to seek for direct payment. What I mean by direct payment is where the subcontractor has an adjudication decision in his favor against the contractor, instead of seeking payment directly from the contractor, I can go to the employer and say, hey employer, instead of paying the contractor directly, pay me instead. So whatever the amount that you are supposed to or due and owing to the contractor, instead of paying it to the contractor, you pay me directly. SEPA allows for that, and that amounts to a payment made towards the account of the contractor. So what the SFC allows for is, it supports that provision in SEPA, but then it begs the question of what happens if it's eventually set aside. Does the contractor has then a right against the employer, or is the recourse against the subcontractor? Well, the SFC provides a provision that in that situation where the adjudication decision is eventually set aside, the contractor does not have a recourse against the employer. Payment that has already made to the subcontractor, it's deemed as payment that has been correctly made towards the contractor.
So that's really quite helpful because there's a lot of contracts that just sit as contracts, and then you've got the statute that sits as the statute, and there's not really a good connection between the two. Nicholas, could we ask you to sort of weigh in here? Because, I mean, Singapore and other jurisdictions have had the security of payment legislation for a long time. How have they dealt with it?
Yes, it's quite interesting. I mean, if you look at the UK, which introduced the Construction Acts in 1980, with a kind of a payment system and a free-floating adjudication system. It provided, first of all, this right to payment, subject to certain notices being issued, and a right to suspension, and then separately adjudication in order to resolve disputes. So you could take a payment dispute, or indeed any sort of dispute, to adjudication at any time. Singapore did something slightly different, and I'm sure you know it. You have to call in the adjudicator pretty quickly about evaluation, so it linked the two. Australia's got a mix, New Zealand's got something a bit different, and when you look around the world, you see people doing different things. It's fascinating to see this kind of progression, because I quite like the idea in Singapore, which came later, to have, you know, evaluation now, and if you don't like it, go straight to the adjudicator now in order to get recompense. And that's great during the project, but when it's ended, if you don't go to adjudication at that final account stage, you kind of lost it for a long period of time. Whereas in the UK, you could let valuations happen and then go to adjudication about one aspect or another one later on. So both have got benefits and issues about them. But I think the best thing about all of it is that a threatened adjudication is almost as good as an actual one. So I think it helps with dispute avoidance. Certainly we found in the UK, people, when it first came along, the industry was a bit frightened of using this new thing. No one wanted to go first. And then once people started using it and the judges enforced it and it became normal, you realised if you were a paying party, that if you were going to speak around or not get yourself in a clear position, objective position about what should be paid, you could be hit with an adjudication and lose because you weren't organised. So you had to sort of reinforce your position if you thought you were right as to why you were not paying, which kind of meant the other party could then look at that and decide whether they agreed or not. You knew what might happen in the adjudication, so it would bring you back to the table for a discussion about what to do. So actually, I think these processes have been quite good. They've taken some years to get to this place. But if you are a sophisticated paying party, you know you've got to do these things, you know you've got to do some more bargaining, it's good. If you're not sophisticated, you just don't organise yourself, then you're going to be subject to a lot of adjudications and lose out badly.
Thanks, Nicholas. So I'm not going to go further into adjudication because that was a subject matter of a 2-day conference here a few months ago. So I'll keep moving. And we're going to move on to Nicholas now, and we're going to deal with the next section, which is that, Nicholas, zero dispute is a heady goal. It seems to suggest the audacity of putting lawyers and arbitrators out of business and breaking our rice bowl. But I know that that doesn't always happen. And why would you advocate for dispute avoidance, dispute prevention, dispute mitigation? Why not just wait to the end? Now, I know you've got some slides, which I will help you to advance. You'll just have to prompt me. Okay?
Okay.
I will just get the slides on. Yep, they're coming on. It's okay. There you go. Nicholas, you're going to have to speak like sort of
Okay. So here we go. Great. Now I can see them now. That's fantastic. Thank you. So if you want to go to the first slide, please. So I suppose I should just explain my interest to all of this. I began life in the mid-80s working in the construction industry, working on projects, training as a surveyor. And I spent the first 8-10 years of my life doing that. Got involved in disputes a bit by accident and then became a lawyer. So I've been a lawyer for a long time. But what has always interested me and still interests me is how you can avoid disputes, where they come from, what role a dispute resolving person can play. And by that I mean a lawyer or an engineer or someone else that's interested in trying to fix the problem. Just starting with this slide here, causes of claims. I still think this is true today. This is from some research in the 90s. And these chaps here looked at loads of disputes on construction projects. And if you were to draw a list up, now all of us, we'd start to write down things like variations, change orders, instructions, extensions of time, defects. There'd be a whole list of things. But what they said is that all of those are just the symptoms later on. The real cause of disputes are these things here. So project uncertainty is the first one. If you take a big project, you can't really get everything in your mind about that project. You can't really deal with everything. Things happen and you're not expecting them, and that creates disputes and uncertainty. The next thing is process problems, and this is something we still suffer with in the industry. Incomplete documentation. Well, documentation doesn't fit together. It happens frequently. Big specifications, employers' requirements, with lots of sections that don't quite fit together, create not necessarily ambiguity in that there's a direct conflict, but you're expected to do one thing one way and something else another way, and you get arguments about that. Or unrealistic expectations, demand for a finish date that no one can ever really achieve, that someone will take the project on anyway, and of course won't achieve it. And then people issues, and this I think is really interesting. I think everyone in the construction industry is really technically competent. I really do. I really believe that. The industry builds fantastic things all around the world, and they do it and they achieve it. But the people issues are quite a funny thing. Poor communication is still a problem in construction. Lack of responsiveness or opportunistic behaviour. So you've got these contracts, we don't look at them, we build, we get on with it. We do a great job actually with building, But when we start to have a process problem or a project uncertainty, we go into our corner and fight from our corner. So I think that's where it starts. So, you end up with a small problem, it's ignored, and it becomes a larger one later. And when there's a lot of money attached to it, then it becomes a dispute because no one can quite deal with it. Could you go to the next slide, please? So this is another slide I found really interesting. It's 30 years old now. If you go to the far right-hand side where it says adjudication on these three pillars, by adjudication, the authors here meant a third person making a binding decision. Whereas on the other end of the scale, negotiation is we're still in charge. If I'm bargaining with you, we decide the outcome. Now, the interesting thing about that is it's actually easier to go to adjudication, let someone else decide. It's their fault if they get it wrong. We're still right. So it's quite difficult sometimes to really remain in charge, negotiating your way out of a problem. And there's variations on the theme, like mutual fact finding or an expert appraisal can be really helpful in construction. If you don't know the facts, or you don't understand the technical aspect, or maybe an early neutral evaluation about your liabilities might help you bargain a bit better and do a deal. And then the middle part, because I think the middle part came to construction much later. And this is a great area, of course, and you've got these in your procedural arbitration rules in the AIAC. You've now got a mediation procedure. And this allows you, if you can't negotiate and talk to each other, to have a facilitator that tries to take you on the journey, but the power to settle still remains with you, rather than handing it over to an arbitrator. So there are all these variations on these processes here, and we can use them in construction. And I just want to encourage people to have a think about some of them, like consensus building, bring in a facilitator to help you on a complex project where you've all fallen out with each other, but you've still got 2 years to go. It's not done very often, but it does happen and it can work. Could you go to the next slide, please? Okay, so I was going to talk a little bit about dispute boards here. So this can cut across your Construction Act or Security of Payment Act where you've got adjudication. But if you've got a very large project, you might benefit from a dispute board. So they kind of can make binding decisions or they can make recommendations. It's a bit more than mediation, but they follow the project from the start. So if you were to bolt this into your project, it might work something like this one here. And this is an example I'm going to use. It's a 7-year project, 900 million euros, sitting across 2 countries. It's the Hadron Collider in the CERN nuclear research facility in Switzerland and France. It's underground here, and they wanted to improve it for scientific experiments. If you just click one more, you'll see the 2 access points. So there you've got one in Switzerland and one in France. And what they wanted to do was expand this project. So it was underground work. So if you click the next slide, please, we'll see that. So there you've got the grey, the old CERN Hadron Collider, and the red is the new. So you've got shafts being sunk, caverns, tunnels. Then you've got a whole load of magnets going in, the world's most powerful magnets made by Tesla. You've got cooling systems, very sophisticated machinery going in there. You can see it's a hotbed for disputes. So what they did was they appointed some adjudicators to follow the project. So if you just click to the next slide, you'll see how this works. So it was a FIDIC-based contract outside of any Security of Payment Act procedures in France and Switzerland. And there was a panel of 5 adjudicators. So they found 5 adjudicators, 2 different types of engineer, one very focused on tunnelling, one on ground conditions, an architect, a lawyer, and then a chairperson. And I was the chairperson for this panel for 7 years. It's in its last year at the moment. So there's a different skill set there of people. And we followed the job. We went every 4 months, went round the site, underground and so on. And if a dispute arose, we could then talk to people. And the main benefit, I think, of a standing dispute board, not from this project, but generally, is that you get involved And when you see problems, you start to question people about them early on. And I think that's a good thing to do. And you can bolt this into any contract. Now, I know if you've got a Security of Payment Act or similar, you might not readily find rules like FIDIC ones to fit in. But the ICE has a series of rules. There's other rules are out there that you could use to easily adapt. If you go to the next slide, please. So just really then, thinking about live dispute avoidance, trying to look at the contract, trying to negotiate constantly with the other party rather than just stand back and say we're right. Maybe using a dispute board or other facilitators on bigger projects. Where is it that we get these problems on projects? So this is just my sort of main checklist for problems that I see. First of all, interface management, between the tunnel and the track, between the electrical systems and the physical building. Sometimes these things aren't worked out properly. The fire protection and how it integrates with the rest of the building isn't always fully worked out. And sometimes when you get on site and everything's happening, this can create delay and problems. Valuing change as it occurs often isn't done. An event occurs, it's parked, the project's going to be late, but you're going to deal with it in 2 or 3 years. How does that work? That's what we've always done, but you forget everything. So if you look at time and money delays, this month now, based on what happened last month, you only have to deal with a 4-week period at the most, and you can look at the delay as it's happened. You can go to site, you can see it, you can try and make an assessment. And I really encourage people to do that on this new form of contract, because you could just go ahead and do that. Great way of avoiding long disputes in the future. And that means making the use of an updated program, those progress reports that Darshendev was talking about, the shopping list of things that you have in the reports. Make use of that as you're moving forward for valuations, updating the program and valuing change. Progress meetings then. Most progress meetings involve people talking about how great the project is. Don't do that. Talk about the problems you've got that you need to solve for next month. People often don't do this. Steering committee meetings. You could have the most senior people come to the project once every quarter because they're quite removed from the project and they can talk about problems. It works quite well again on quite big projects, but it works on small projects too. Cheaper than the dispute board, senior people coming together every quarter just to try and crack problems on site. A lot of people don't do it, but I've seen it done and it works. Risk registers, I think they're great. Go with the early warnings. So if you've got a risk register of problems that you think are coming up, you can talk about those at every progress meeting, try and find a way to deal with them. And if you colour them up, red for super important, orange for vaguely, and green for we've sorted it, gives you a way to manage it. Plan date for completion and time for completion. If a project's super late and no one has dealt with the extensions of time, that isn't giving you a date when the project's going to finish. So don't worry so much about what the contractual date is if you can't agree it, but you can plan ahead to when the project will finish given all the problems that you've had, because if it's going to be late, it's going to be late. And then finally, dispute board visits. If you've got a dispute board, use them, make them go to site, rather than let them sit in the wings in case there's a dispute. Get them to site, get them involved, they'll get to know the people in the project and they'll make helpful suggestions about how to push the project on. And if there's a dispute, they'll fix it quickly and more economically. So I think if you go to the last slide, you'll see that we've finished. Thank you.
Thank you. AIAC, could we bring Nicholas back on the screen, please? So whilst we're doing that, do think of your questions that you want to discuss, but I'm going to kick it off first with just one question. Nicholas, you're back. That's great. We were kind of missing you.
I was always here.
Yeah.
We were virtually hidden in the virtual world.
In the metaverse. So, Nicholas, a lot of us will say, a lot of people here will say, but that's in Europe. I'm sitting on the dispute board at the moment in Asia, and I know I'm like hen's teeth. It's so seldom because in Asia, it says, Europe, plenty of money. In Asia, so expensive lah. And why would we want to spend all this money during the course of the project? My Tan Sri will talk to your Tan Sri, and we'll get a settlement. So how do you Asianize it?
So, I mean, the interesting thing about it is, I mean, I've worked a lot in Asia, and I mean, I'm sitting on dispute boards at the moment in Nepal and Indonesia, and the reality is, the cheapest way to use a lawyer is to use them in that process. I mean, I probably shouldn't be advertising them like that, but it is. You know, if they're doing a huge arbitration, you're stuck with them for years. I mean, I'm a lawyer, I'm dual qualified, but if you have them rarely going to site and getting involved, you know, they can help you understand the risks and they can help you discuss the project and so on. And I think, you know, when you say Europe's got plenty of money to do it, I think that Europe has learned it's cheaper. I mean, CERN, 900 million euro project, it hasn't cost any more than that, and it's finished on time. And if you think about a project that has a low budget and kicks off with an unrealistic completion date, they just spend a fortune sometimes trying to get these projects back on track. And so I think that on any international project, the cost of a dispute board or project mediators is another one that's quite good, and perhaps good for Asia also. Can save its money. There's some research in the States about dispute boards you can have a look at if you wanted to. The other thing, of course, is just to carry on as you are and keep us all busy in arbitration later on, which is, I suppose, what we all want in our growing practices. So, you know, the construction industry can make its choice really, but anything, I think, to get disputes into the project. So, in other words, rather than spend 4 years in a project and then 4 years in an arbitration, don't do that at all. Try and deal with the disputes by having risk registers, managing the issues as you encounter them, and make decisions. I know one problem you frequently see on big projects is that no one on the owner's side feels they've got enough authority to bargain away very large claims. And that is difficult. Sometimes it's easier to leave it to the end and let someone else do it. But again, that's a place for dispute boards. They can come in short periods of time, make binding decisions. Deals with the auditability of disputes. So anyway, so that's just some ideas.
No, I agree with you, Nicholas. Kok Keng, have you seen much or any dispute boards being used in sort of the Malaysian context?
Basically, from my experience of 20 over years in Malaysia, I have not come across any client that is willing to pay for a dispute board. Because to them, I think they actually relies on the contract administrator to be the first person to resolve the disputes. So they would rather save all the money they can.
Has anybody in this room come across a dispute board? Yes. Where was that? Vietnam. Okay. And?
Oh, yeah.
Also Vietnam. Same, okay, it's the same project. That's cheating. How can you get two people on the same project? But no, I think that this is an issue in somewhere like Malaysia. I think Vietnam, I agree with you. I've seen dispute boards in Vietnam and Philippines and all that. But to be fair, I've also mainly seen dispute boards in Asia where there are multilateral banks involved. You know, so like the project I'm on, it's a multilateral bank involved. Darshendev, I think you've got something to add?
Hi, yes, I do agree. It's very rare here. But just to touch on one point where I think Nicholas was mentioning earlier that it's always cheaper, or it's most cases cheaper to get the lawyers and consultant on board during the project as opposed to during the dispute stage. And I totally agree with that for the very reason that when the lawyers and consultants are bought during the project, it assists in terms of checking and making sure that the issues are well taken care of, the documentations are in order, so that tomorrow when there is a dispute at the end of the day, the papers are in order, and or you may even end up having not very much dispute at the end of the day. But many clients have this perception that why do I need to pay a lawyer or a consultant at the initial stages of the project? Might as well I only look for them at the end of the day if there is a fight. And we know, particularly in construction dispute, very likely there is going to be a dispute at the end of the day. And the analogy that I would give is pretty simple. Take yourself, for instance. Why do you watch what you eat? Why do you exercise? Why do you eat supplements and medication? for the very reason that you're investing in yourself, so that at the end of the day, you will have less complications if you do fall ill, and you'll end up paying less to a doctor. So if you can think about investing in yourself to avoid at the end of the day paying more and dealing with a more complex situation in yourself, treat your company the same way. Invest in your company by investing in good lawyers and consultants.
Which actually reminds me of an analogy that somebody else drew for me some time ago, which was that as lawyers, your clients are always asking you to reduce your fees, right? And they're always saying, we want something cheaper. But the question to ask back is that if you're going searching for a heart surgeon, would you choose your heart surgeon on the basis of the person who is the cheapest? Or would you go with the best? So I think that along Darshendev's lines of argument, do have a think about that. But on that basis as well, we often hear a lot of people saying that, look, dispute boards decisions, CIPA decisions, they get overturned anyway. They get challenged anyway. We end up going to arbitration anyway. Why bother? Comments? Yes. Isaac, can you please introduce yourself? I know you. Many people know you. Some people don't know you.
Okay, my name's Isaac. I'm actually a building surveyor and also a building engineer. I'm
just going to add that Isaac is a very important person in the Chartered Association of Building Engineers. CAPE.
Yes,
Yes.
That's right. Yeah. No, my observation. I mean, I've been in the industry for a long time, but in Malaysian context, it's just basically a lot of it boils down to money. A lot of developments on the private sector are actually done without securing enough funding. Especially like you say, the housing developers, they depend on the sales of property. So they have a cash flow problem, which will invariably arise. I was involved for about a decade with the central bank in Malaysia, reviving abandoned projects. Now, abandoned projects mostly are abandoned because of financial difficulties. But when central bank took over, they parked $1 billion to, Malaysian ringgit, to revive all these projects. And we revived more than about 5 million to about 20 million worth of development that was left abandoned based on this. And all the contractors that we engaged, we had not have any problems that ended up in arbitration because we had money. The bank put in 1 billion into the big 6 accounting companies, which in turn employed project managers. The fact that the contractors knew that we had money to pay, the disputes just vanished. And people just did the job. So in Malaysian context, finance is a big issue. So I would say that introduce payment bond for projects. Now there was once I think even our judge, one of the judges that is involved in construction before, he wanted to introduce into CIPA itself payment bond, but towards the end I think he didn't get his way. So payment bond I think is the way forward to have, if you really want to do something like zero disputes, in Malaysian context it will bear fruit. Thanks.
Thank you, Isaac. In fact, in CIDB 2000, what we did was that we made a payment bond as one of the options, and to balance it up, we made the performance bond also as an option, unlike in the normal situation whereby you never see a payment bond, but you always see a performance bond. The other thing that we've always talked about also is, for example, payment by letters of credit. And all these have been pushed by the wayside. Gentlemen, I'm going to suggest to you, speakers, that actually the situation that Isaac talks about has become much, much worse today. And Darshendev, I'm going to ask you particularly, again, I'm going to come back I'm going to come back to my original question, which is that even with CIPA, everybody is challenging it. I know that the statistics are that really only 20% are being challenged, but nevertheless, there is still that mentality of challenging things, getting things overturned, and delaying it. So what are your comments with regards to that?
Okay, I will start off by saying, and I agree with Isaac, and the phrase is cash flow is the lifeblood of the construction industry. No way you can run away from that. In order for a project to work, you need cash flow. If there's no cash flow, the project's not going to work. Many years ago, before SEPA came on board, there were provisions in the contract which allows for back-to-back payment. It's where the subcontractors are only paid by the main contractor when the main contractor is paid by the employer, so on and so forth. There are also provisions in the contract which states that the employer can impose LADs or back charges, and the contractor can't bring a dispute to arbitration until the end of the project or in the event of a termination. So what happens is that if you are a contractor who is financially strong, you may be able to continue with the project and reserve the fight at the end of the day. But that may not be the case for all contractors, and that may not be the case for most of the subcontractors, subcontractors, subcontractors down the road. Many of them need cash flow on a daily basis. They need to pay their suppliers, they need to pay these guys, they need to pay the brick guys, they need to pay, etc., etc. So how do we then resolve this? How do we then inject cash flow? And that's where I think Isaac was saying that that's led to a lot of abandonment of projects in Malaysia. So the government went around and started looking and said, okay, look, why don't we introduce SEPA or the Adjudication Act? What Adjudication Act promotes? Two main things. Number one, all pay when paid clauses are statutorily void. So even if you have such clauses in your contract, you can no longer rely on that clauses, number one. Number two, it allows parties to proceed to refer a payment claim to an adjudication, and within 3 months, you get a decision in your favor. Now, some of you may say, but there was already an adjudication process in some of the older standard forms of contract, but that didn't work. Yes, that may not have worked probably because the architect or the contract administrator was the adjudicator. He may deliver a decision, whether independently or not independently, depends. And even if he has delivered a decision independently, what pushes the employer to honor that decision? Nothing. There was no bite in it. But with SEPA, there are statutory weapons that have come in. Number one, I can suspend work immediately. That's a real hit to the employer. I can reduce the rate of my work. I can even proceed to seek comments winding up proceedings. I can even get payments directly from the employer. So these are all the benefits that SEPA gives with the aim of promoting cash flow. So from where I see it, if an employer had properly assessed a claim with proper documentation, he need not be worried or concerned with SEPA. It is meant to deal with employers or contract administrators who do not properly assess a claim. Now, those are the benefits. Coming to Sureem's question, but a lot of these decisions are being challenged in the High Court, and it may go on to the Court of Appeal, and it may even go on to the Federal Court. Well, the reality is the chances of setting aside an adjudication decision is fairly slim. And I think the courts have taken a consistent approach that even if the adjudicator has gone wrong, unless it's a grave error which goes to fraud, corruption, breach of natural justice, courts tend not to interfere with an adjudication decision because, for the very fact, this is intended to be an interim, rough justice. You pay first and you argue it later at the end of the day in your arbitration proper. So whilst there are challenges that are being made against decisions of adjudications, but the chances of them succeeding is slim. But look at the bigger picture. It has helped many contractors over the years to inject cash flow into the project which they were deprived of, or I would say which they were suffocating from, not getting for a very long time.
Yeah, in fact, on that basis, I mean, as much as we talk about that, please bear in mind, if you attended some of the other SEPA conferences, you know that really the courts only see about, if you compare the statistics of cases in court versus the statistics from AIAC as to the number of adjudications, it's clear that only about 20% of adjudication decisions get challenged in court. So you got the 80-20 rule. The 80% are still valid, and it's actually being acted upon. And anecdotal as well from contractor friends who are saying, hey, Swee, this has actually really changed my life. So let's not despair. Let's not always focus on the glass half full, right? Let's go with a more positive feel about it. Yes, Linda, can you come and introduce yourself?
Yes, my name is Linda from RACSI. I'm an expert. Come to the point where we talk about cash is king, the lifeblood of the projects. I think apart from that, the role of the contract administrator is very important, right? Because the role of the administrator is to advise the clients and also to assess the claim independently and impartiality. Why we lead to dispute? Dispute is because the SO, the contract administrator, refused to assess the claims, refused to assess extension of time.
Linda, I don't mean to stop you there, but Kok Keng is actually going to be dealing with that in
okay.
the very next session. Could you
very excited.
Could you hold your question to after this session?
Sure, no problem.
Thank you.
Okay, thanks.
Thank you. Kok Keng, you said you wanted to add something to Isaac's comment. It's okay.
Just to add to what Isaac has said, I do agree with him that if the for a project, if the source of finance is already there, generally dispute, I believe, can be minimized. Now, for contractors, I mean, from my experience working with the mid and the lower size contractors, generally, they don't mind taking a loss as long as they get paid. So even if there are minor dispute which they really don't agree, like, oh, I'm supposed to get this VO, but you did not certify me. But for them, as long as I get paid, I just lose some and take it and go elsewhere to find my money elsewhere. So that perhaps if for every project, if the source of finance is secured before a start of a project, that will really help in reducing the dispute.
In fact, if I could just add, and I think for the record, not in every occasion you can blame the employer. Sometimes the contractor also can be a bit mischievous. And we know, for those who have been in the construction industry for a very long time, would know that many a times contractors, when they put in their bid, they go in low just to get the job. And then they try to pad it out with various form of VOs. So just for the record, although the discussion is slanting towards as if the employer, it's or more of the naughty guys, but we must also bear in mind that's not the case all the time. There are also instances where the contractors are also not behaving properly, if I may say that.
Nicholas, what do you think?
Yeah, absolutely right. I mean, when I was saying before, people take their positions. I'm not necessarily suggesting that it's a rejection of the claims all the time wrongfully. It may be that the contractor hasn't understood that they just don't have a liability, and that's that. And going just back to something that was said a little earlier, you mentioned the 80-20 rule. In relation to adjudications in the UK, the domestic ones, which has now been going for 25 years, less than 2% are challenged. So more than 98% are honoured. Mostly that means payment or an acceptance of the outcome. Only a very small amount are now challenged. So it's become very clear that if you've got a decision, you've got to get on and follow it. Otherwise, the judge is going to make you follow it promptly, and the appeal courts have made it clear that they will go with that approach. So the rules are set now. The ones that are challenged successfully are where there isn't jurisdiction or something quite limited and obvious mistake. So basically, it's the pay up and get on with it approach has meant that people do take it really seriously, and that I think is helpful. That reduces then this time wasting of appeals and so on and so forth. You know if you lose, you're going to have to pay. So you put your effort into trying to win or deal with the adjudication properly, or bargaining in a better way beforehand. You know, it forces you to look more proactively if you want to avoid that world of constantly having little battles.
Well, SEPA will be 10 years old next April, and we'll see whether we've learned some lessons from it, because I think, as Darshendev is saying, we've had the growing pains, but we've also had, I think, a very settled sort of policy as well. But let us move on. Let us move on to Kok Keng. And Kok Keng is going to, I mean, look, we're all lawyers, right? He's an engineer. So he actually deals with the people on site, and he gets his boots dirty. So let's hear from Kok Keng as to really who needs to do what and when in order to benefit from the AIAC standard form contract provisions. Over to you, Kok Keng. I'm sorry, the AIC, could we have the slides up, please? Sorry, Nicholas, we'll have to see you in a bit.
See you in a moment.
Yeah, hopefully, after my presentation, at least I will demystify what Darshendev has said about the employer not doing the job. Actually, everyone in the industry need to do their respective tasks. Okay. Right. Being an engineer in the room, I will just dive straight into the topic, how to benefit from the AIAC standard form of contract tools of dispute prevention. Okay, allow me to start off with a case study of a 6-month factory piling and pile cap contract to demonstrate how dispute arises and turns parties' relationship from friendly to hostile, right? So I think that those on the ground will think that 6-month piling project for a factory, what could go wrong, right? It's a simple project, right? So as usual, when the contractor starts the work, then it is assigned that the contract administrator is the designer, right? Now, when the contractor starts the work, together with the employer and the CA, parties are very friendly. They go to drinks, they go to lunch, right? Together, they pat their shoulders. Some say too friendly until no need to write any letter, right? So in this case, even for the setting out delay, no notices, right? No notices were submitted. And then coming to month 4, CA then rejected the EOT claim for setting out delay due to no notices. Now what happened? Shields up, guns out. Contractor panic. Start writing all the letter. Followed all the contract provision to the dot. This is what's going to happen, right? Now, by month 5, it's compounded by side issues like short piles. Okay? Now, for the benefit of non-technical people in the room, short piles is a situation where you're supposed to install or drive the pile to, say, 10 meter depth into the ground. But you only manage on site to drive to, let's say, 5 meters. So at 10 meters, you're supposed to achieve 100% of the capacity, but at 5 meters, mathematical-wise, you are achieving 50%, right? So this is due to a presence of a hard layer in the ground. Okay, and at the same time, in month 5, the contractor, through the insurance agent, wants to renew the insurance. The insurance agent will say, I need a certificate of EOT before I can renew it. Because don't forget, month 5, next month, is already month 6, when the original contract completion is coming to an end. Now, at the same time, at month 6, with the issue of short piles, the CA is now then bogged down to solve the short pile issues because the ground condition is erratic. Some here, some there. Client say, save cost, save cost, save cost. So, CA being also the designer, trying to solve the issue. Coming to month 7, right? And to be precise, on the last day of the 6th month, the CA finally issue a certificate EOT. Pass it to the contractor bring it to the insurance company to renew the insurance. Insurance company say, hang on, I need 10 days because of my internal process. Now then, another dispute arises, which is for that particular 10 days, while waiting for the insurance to be renewed, no work can be carried out. Of course, the CA will say, under the contract, you're supposed to renew within 1 month or whatsoever. Right. Now, we can see here from the procrastination in solving dispute number 1 has then led to the rise of dispute number 3. Okay? On month 8, finally, the CA resolved the site issue of short piles. Proudly issue the design. But at the same time, the CA now is caught conflicted to assess the EOT as well as loss and expense, arising from the short pile because he is also the designer. You see the conflict here? Okay. Now, sorry. Now, from just the case study of the 6 months, what we so-called simple case study illustrated, I find that we can benefit from the AIAC standard form of contract by, number one, utilizing the option to choose a CA, right? A good SFC is as good as its administrator. Because, like it or not, when a dispute arises on the site, the first person it will refer to is the contract administrator. Now, by having this option, it allows for the role between the CA and the designer to be separated, and this avoids conflict, right? No man can be a judge of his own, right? This is what we always hear, you see? Now, it allows placing the right person to do the job. Now, secondly, I coined a term from my work as a delay analyst to say that to administer the contract prospectively and not retrospectively. Now, what does it mean? Is when the work progress, or as the work progress, follow the contract provision. What needs to be done needs to be done. Don't wait. Don't procrastinate. Best of all, on site, you can see that when they don't meet it, some will try to backdate. Right? With the technology available, some even PDF, change the date, change this, change that. People are very creative, you see. So this is the problem now. Now, I just give you an example. I think some has been given by Nicholas as well as Darshendev. I'll just elaborate it a little bit. Now, for example, work program. You start off with the contractor submitting a work program. Many a time what we see, a simple 10-line Excel work program. No link. You don't even know what's the relationship. Finish to finish, start to start, finish to start, finish, start to finish. I also confused already. Right? But by right, a good program should be properly linked. It should be level by level, trade by trade, sufficient details, right? And, you know, Malaysian clients, sometimes you will see provisional sum up to 60% of the contract value. Contractor paying for yada yada, like the retention sum, performance bond, etc. But it is good to indicate the lead time required for all these items so that CA is aware of his role, when he's supposed to finalize all this and get it done, see? Now, this is very important. So once that is updated, submitted to the CA then review, and then approve it. And parties then go take it on to then track it. Without all this sufficient detail, you can't really track it, right? So when there's an EOT approved, contractor again submit a revised work program, and then the CA will then again review and then approve it. Now, moving forward, once the work program has been approved, it's the tracking of the work progress. Okay? So you got to track the work progress. You got to update the work program. No point having a work program but not updated, because these data will be very useful. I mean, there's no wood here, but touch wood, if it's going to go to a full-blown dispute, you need all the data for a retrospective delay analysis, right? If you don't have, you can't really do it. Now, update the work program. Keep it tracked on a periodic basis. For the progress report, I think Darshendev has dealt with it, but I just briefly go through is that you need to have the physical S-curve, financial S-curve. You need the summary of resources, summary of weather. Now, you may think that no point having the summary of resources or whatever, but when it comes to a loss and expense claim, that might be your first basis of evaluating the loss and expense claim. Now, coming to add on to that early neutral warning system. In fact, actually, we on site, on the ground, has been practicing having meeting, right? Meetings after meeting and meetings after meeting. But in those meetings, it is actually where we actually recorded the list of issues and events that will impact time and cost. So we need to act on it like what Nicholas has said, not just putting it in the minutes for the sake of putting it in the minutes. Okay? So those are things that you have to do for the work progress. And for instruction, let me just share some things I face on the ground. What do I get as an instruction? Minutes of meeting, site memo, NCR, and best of all, construction drawing revision 1 to 12, 13, 20 is coming already, right? But realistically, under the contract, what does it say? You're supposed to be, as a CA, issue an instruction as a CA instruction, and not any other document. this is stipulated in the AIAC SFC, which is, I think is very good because expressly, at least disallow all this kind of backdoor methodology to solve their non-compliance, you see. So, contractor, again, don't be shy. You don't receive an instruction or you are unsure whether the instruction is valid or scratch your head. Just issue a CA, confirmation of CA instruction, right? Nail it in. No need to scratch or waste your brain cell to think whether valid or not valid. Now, most importantly, one thing I always see, not just the CA, employer as well as the contractor that did not comply. Everyone didn't comply. They didn't serve it to the right address under the contract. Contract got this employer who the address what? Nobody follow. When we got this provision for service of notices, right? Should be by facsimile, by hand, or by register post. Nowadays, due to convenience, everybody WhatsApp, Telegram, and then they lost track. When you ask them, did you send something? It was in the WhatsApp. I need to download. But it's not a valid instruction under the contract, you see. Now, lastly, on the procedure, timeline, and assessment and certification, I just give a simple example based on extension of time. So, it is a process and procedure that we have to comply by the contractor as well as the CA. So, within 28 days of the occurrence of the delay event, the contractor is to put up a notice, right, to notify the intention for a delay, to claim for a delay, right? And then in that particular letter, he need to give an initial estimate as well as a brief description of the delay. But sometimes, some contractor will say, how to give an initial estimate of a delay when it's an authority issue? So I will tell them in Malaysian language, it's hantam dulu lah. 10 days, 15 days, then put there subject to the authority approved by certain date. So that's the only best solution that I can think of. Now within 28 days when the event has ended, then the contractors to submit full particulars of the claim comprising of the critical path analysis, supporting document, right, and a description and how the delay actually impacted the overall contract completion date. Okay, but realistically on site, contractors are too busy with the work. All these, at the end of the day, or most of the time, are not complied. So, their claims are generally rejected, right? So, if the CA did not, one more minute. So, if the CA, upon receipt of the claim, so if he feels that he needs further particular, he needs to then ask for it within 14 days. If no further particular is required, the CA is to reject or issue a certificate of EOT within 42 days. So these are the procedures and and timeline required. So I believe the above will at least, try to prevent dispute, if not minimize dispute. With that, I end my presentation. Thank you.
Thank you, Kok Keng. AIAC, can we get Nicholas back on the screen again, please? Welcome back. So, ladies and gentlemen, I was told once, you buy a gym membership and you expect to get fit and lose weight. Well, the trick is that you buy the gym membership, you actually got to go to the gym and use the gym, because otherwise, you're just wasting your money. So, I think that Kok Keng's message here is that the AIAC SFC, using all those clauses that Darshendev was telling us about, only works if you actually use them and you do it. And he's given you some insight into what you should be doing. Yeah? Darshendev, what do you think?
I totally agree with that statement, because I have had a matter in the past where we were dealing with one of the clients and I asked them, okay, so have you followed the certain provisions of the contract? And one of the guy who was actually their so-called contract administrator looked at me and said, oh, since the contract was signed, we kept it in the cupboard. I haven't opened it until now. I've been just doing my way of how I usually do. But this is how it's done, what? This is how it's done, what? I've been an architect, I've been an engineer for so many years. This is how it's done. But I said, you look at your contract. Forget about how it's done. The contract is worded as such. So, so I do agree that a contract administrator plays a very important role. I think that was one of the questions asked earlier. But I also have a bit of a sales pitch here, that if the contract administrator is very busy, technical, is working on the work, no problem, get a lawyer on board, he will help you from the beginning till the end.
I actually have worked on some arbitrations where there was a claims consultant hired by the contractor. And this consultant came in, I think, half a day each week. This entire arbitration, we had lever arch files of paper. These were the days before electronic documents. And all the letters were written, actually, by the consultant on behalf of the contractor. The employer didn't have a single letter. Guess who won? Nicholas, is this just a Malaysian problem?
No, it's a common problem worldwide. I think that the industry is the same the world over, really. And yeah, as I was saying at the start, I think people are technically very good at what they do, but some hate paperwork, some like it, some just get on with the project and ignore the contract. But we live in a world now where everybody does need to get the contract out and have a look at it. They do need to keep records. They do need to make their positions clearer. And that's one good thing that adjudication started to do, and these payment procedures started to do around the world, is make people realise they have to, get on and actually run the job by virtue of the contract and the paperwork. And also, whether you're forgetting the lawyers at the moment, if you're a construction professional, you are a qualified professional. You've got a degree and professional qualifications. And I remember one judge in a case involving a football stadium years ago, no notices had been served, and they tried to say that's because we were getting on with the job. It was all very technical, etc., etc. And the judge said at the end of the submission, he said, I've looked at the people running this job. They're super qualified. They've got degrees and masters and so on. None of them could send a half-page note saying we've got this problem. It's baffling. And we all can see that's the way we get on with the job. But, you can also see that the judge's point was, why not just send it? Why not just do it? So I think, it's really important to start to look at the paperwork. And that's sort of what you're paid for if you're running a job for someone, isn't it? You're paid not to just build the job, but actually have it so that it's an auditable project, because it's not your money, isn't it? If you're working on a mega project, it's not your money, it's someone else's, really. It's a bank's or the government's or whatever it is, and your job is to build it and to document it. So if there are issues, you can resolve them, or at least, to make sure the BIM models are right and the records there and the operation and maintenance manuals, which often are lacking too. The world at the moment is moving towards a much more systematic, detailed recording of how projects are built to make not just the financial outcome easier, but the running of the project in the future and easier.
So, Nicholas, what I'm hearing from you is the message is that a construction project is not just about bricks and mortar, it's also about the paperwork. It's part and parcel of it. We don't no longer think of it as an adjunct, an unnecessary annoyance. It's actually core to the project. Yes?
I agree. And it's not just about the accounting process at the end and unravelling claims. It's also so that the people that run that project for decades kind of know how it fitted together. You think about how often you take over a new project and you haven't got the documents you need to run it properly, or you're trying to go back and fix something in the future and you don't know where the cables are, the maintenance hatches and all sorts of things. It's all part and parcel of that. The BIM model, the detail of everything went into it, the financial implications of it. It's all part of these new kind of systems as well for gathering data. Because, now it's easy to be overloaded with data, isn't it? And you see it with these different systems that are out there. And it's part and parcel of running projects. The information is there, and the systems are there now to help everyone do it.
So, Linda, I'm sorry I cut you off earlier on, and may I invite you back again? I didn't mean to cut you off.
Hello. Yes, no worry. It's very important. SO is a person that actually have to certify the work done and the rest. And what Dash actually pointed out is that the contract administrator do things on his own style. I think that has to be rectified because contract administrator is very important. It's a dispute resolver, to put it this way, to certify what he thinks is entitled to the contractors and the parties. Okay, so my question is that will the AIAC have this role, be providing any services to train and also to adjust the mind of the contract administrator so that he can basically do a proper job? Like what NEC and Fenwick is doing, they're trying to qualify their own engineers with the proper training and qualifications.
AIAC is an arbitral institution. The fact that they've gone into standard form contracts, I think it's already a step out of their comfort zone, so to speak. So I'm going to leave the engineer to talk about the next step.
Okay.
Okay, let me just
Thank you.
answer Linda's question. Thank you for your question. Okay. Actually, what you have highlighted is it's very relevant. Many dispute arises from the CA. So now that we have an option to choose a CA, the question, like what you say, is how to choose a right CA, and the CA must be accredited. So I've done some research. What I found is you only have a certified project manager by PMI. I think for FIDIC you have a certified contract manager, but I think Mr. Trung here can confirm that. So really, I don't see certified project manager under PMI is sort of closely related to construction, because from my experience as a CA, to be a CA, you really, first thing, needless to say, you need to be versed with the contract, the procedure and the process. Now, secondly, sometimes on site you actually act like a mediator. You have the main con and the employer dispute coming to you for resolution. You have the consultant, among them also will dispute, architect, CNS and M&E also will dispute. My cable wants to run this way. No, you cannot call my beam. My beam you call is going to collapse, this guy, you sign or I sign. So this kind of thing will happen. And then you have the dispute between the contractor and the consultant. You also have the dispute between the contractor and the subcontractor. So now how to become a good CA? You actually, apart from contractually competent, you need to be also technically sound, right? Technically sound. You need to know how site is being run. You know how things are being built. What is the sequence, right? Then going from the main con, let's say an example between the main con and the subcontractor. The main con, the subcontractor coming to you, hey CA, the main con doesn't allow me to enter. Then you got to go and see why does the main con doesn't allow the subcon to enter, right? Or if the job awarded in this way, will it cause more conflicts or dispute, right? And the role of CA, it starts actually from design. Now, I have an experience, just to share, is that, okay, I got to wind up already. So a quick one is that it's something like an independent outlet located next to a river. I was the CA, client comes to me and say that, I want to build a basement. I just sense it, be prepared to pay additional 100% cost plus EOT because water will just keep on gushing into the basement. So these are things that you have to control from day one. So lastly is, yes, currently in Malaysia, there's nothing to regulate CA, but if the CA here is another engineer or another architect or another QS, at least they are regulated by their own respective professional act under the law. Thank you.
Thanks very much. So, ladies and gentlemen, thank you for being with us for the last 1.5 hours. Will you please thank our speakers, Darshendev, Nicholas, and Kok Keng? And I just wanted to close off by basically saying this, that for all the contract provisions that have been provided for in this, what is apparently a very thick form of contract now, for all the problems that you have on site with money, with people and all that. But as Nicholas said, if you go back to court, and in my case, I sit as an arbitrator and adjudicator, so many times I so understand the case that you have as the contractor or the CA. I so understand the sense of unfairness that you have, but I just simply cannot write an award to pander to that if there isn't any evidence, because I know full well it will immediately be overturned and it's of no use. So, ladies and gentlemen, we need to do better with this. And I'll leave you with the fact that I believe that we all can do better together. Thank you all.
Thank you.
Thank you. Thank you to our panel speakers and our moderator for this really engaging session so early in the morning. They did a tremendous job at waking us all up from the night before. We'd like to invite Danesh Chandran, Assistant Director of the AIAC, to come on stage and present a token of appreciation to the panel. And to Nicholas Gould, if you're still on the call, we'd really like to have you at an event in the future here physically. Thank you so much for joining us.
Thanks a lot indeed. Have a great rest of your day.
In the metaverse. Ladies and gentlemen, another round of applause for our panel. Thank you. Before we proceed to our second session of the day, we'll take a short networking break. Please join us for some light refreshments at the pre-function area right next to this auditorium. And we'll see you in the auditorium at 11:30. Thank you.